Hello, everybody. Thank you for joining Steve Raucher and me for the Beverly Hills Bar Association's annual insurance law update for 2022. Steve Raucher is with me. He is an insurance litigator. That's one of his specialties. And the two of us I've given this update a few times, I think, for the Beverly Hills Bar. Without further ado, I understand all of the usual things that we would say regarding getting your credits and filling out a survey and so forth are in the chat. You won't have to hear me say them. Steve, you want to go with our first slide?
Yes, here we go.
The last year, there was just one Supreme Court case on insurance, and that was the case of Yahoo Inc. versus National Union Fire Insurance, 14 Cal 5th 58. So this was a case that came to the California Supreme Court through a question that was certified by the Ninth Circuit. Yahoo was sued under the Telephone Consumer Protection Act, TCPA. That is the statute that restricts robocalls and junk faxes. And they tendered those claims to National Union on their policy, and National Union rejected the tender. So Yahoo sued in federal court for coverage of those class action claims, and the district court granted the carrier's motion to dismiss, and Yahoo appealed. The Ninth Circuit certified the following question to the California Supreme Court. Does a commercial general liability insurance policy that provides coverage for personal injury, that is injury arising out of oral or written publication in any manner of material that violates a person's right of privacy, that has been modified by an endorsement with regard to advertising injuries, trigger the insurer's duty to defend the insured against a claim that the insured violated the TCPA by sending unsolicited text messages, advertisements that did not reveal any private information? So that was the question certified to the Supreme Court by the Ninth Circuit. The question obviously was, what is California law on that issue? So typically claims for the TCPA are argued to be covered under personal and advertising injury coverage under a typical CGL policy. But this was not a typical CGL policy. But personal and advertising injury typically covers injury arising from oral or written publication in any manner of material that violates a person's right of privacy. And the standard policy excludes TCPA claims, but Yahoo had what's called a manuscript policy. That was a policy that was the result of negotiation between Yahoo, which obviously has some market power and some assets to pay a premium, and the insurance company. So they deleted the TCPA exclusion, but they had an endorsement that also excluded coverage for advertising injuries, which are oral or written publication of material in an advertisement that violates a person's right of privacy. So that the Yahoo policy only had personal injury coverage, and the issue was the distinction between the privacy right of secrecy, which is disclosing private personal information, and the privacy right of seclusion. The district court found that the TCPA claims implicated the privacy right of seclusion, not the privacy right of disclosure of private facts, secrecy. And so because the TCPA claims focused on transmission of unsolicited text messages and not their content, the district court found that the TCPA claims were not covered. The Supreme Court agreed with that analysis, but they found that the policy could cover TCPA claims if coverage is consistent with the insured's reasonable expectations. Now, you see the headline that I gave to this case was that the California Supremes punted, because they really didn't take a position on whether the policy did cover the claims. They sent it back that when the Supremes, our Supreme Court, gave that answer to the Ninth Circuit sent the case before them back to district court to resolve the issue of what were Yahoo's reasonable expectations in the district court. In this case ends up, although I think it was pretty hotly anticipated, because of course a lot of the large communications companies are at risk of being sued for TCPA for text advertisements and fax advertisements, these blasts. In fact, the outcome was a really pretty limited application. First of all, you've got to have a manuscript policy where you can negotiate away the TCPA exclusion. So big ones like Yahoo who can pay for that. And the main thing is that it all depended on the insured's reasonable expectations, which is will be a very fact-specific analysis and wouldn't apply to all those policies regardless. So it was, as I say, hotly anticipated, but not very excitedly received. Steve?
I think that's right. And we started with the Yahoo case because it's really the only California Supreme Court case this year on insurance. And generally speaking, that's where we like to start, with what the California Supreme Court did. But I agree with Mike that the case is of somewhat limited application, although I'm sure policyholders, lawyers will try to argue from this case that TCPA claims, junk text claims, are indeed covered. But that'll be the subject of future litigation, I'm sure.
Certainly going forward, those insureds are going to want to create a record regarding their reasonable expectations of coverage, right? Now that they know that that's the analysis that the Supreme Court made, from an insured standpoint, you're going to want to try and build a paper trail for that to support your claim.
I think that's right. And so before I get started on what I consider to be the most important insurance case of the year, even though it wasn't from the California Supreme Court, I did want to encourage folks, if you have questions or comments, to use the Q&A function. The Q&A function is open. The chat function is not. But the questions will come to Mike and I, and we'll do our best during the course of the presentation to look at them and answer them if we're able to answer them. And also, depending on our time limitations, because we do have a fair amount to get through. But definitely, please share your questions with us. I see that we have one right now, but I'm not going to pose it just yet.
Sure,
I want to get to this 24th and Hoffman case. So as I said here, my question is this the sleeper case of the year? Is this the one that is going to have the greatest impact on California insurance law and on policyholders going forward? The reason I asked that, and this case, along with all the cases that we're going to talk about in the first section of this presentation, are about third-party general liability or third-party liability policies. And this particular case, 24th and Hoffman, opens the door to insurance companies being able to contract out of what otherwise is an obligation imposed by California law to defend, quote unquote, mixed actions. That means an action that alleges both covered and uncovered claims. And pursuant to the bus case, which we'll come back to in a moment, if you've got a plaintiff's complaint that alleges some causes of action that are potentially covered and some that are not, the insurance company normally has to defend the entire case with a potential right of reimbursement after the fact. The facts of this case were that Northfield issued a commercial general liability policy to 24th and Hoffman, which owned an apartment complex. And the fact pattern was, not atypical for apartment owners. You had two tenants who sued alleging multiple habitability claims against the landlord, but you also had a couple claims, conversion and I believe trespass to chattels, which complained about things that were unrelated to the habitability issues. They claimed that they had personal property in a storage locker at the complex, which had been damaged by the landlord's contractors at some point. Northfield, when the claim was tendered to it, refused to defend because there was a habitability exclusion, which again is not uncommon, but the particular language of this habitability exclusion was a little bit unusual. So the first part of it was sort of a straight habitability exclusion. It excluded claims alleging or rising out of the actual or alleged violation of any federal, state, or local law relating to habitability. But the kicker was that it also excluded causes of action alleged in any claim or suit that also alleges any violation, breach, or wrongful eviction, etc. So in other words, the exclusion purports to exclude coverage for an entire case if it involves just one habitability case, even if there are other habitability claim, even if there are other claims that are not habitability claims. So Northfield refused to defend, and so you had the plaintiff in the coverage case defend the underlying case and settle it, and then sued Northfield for wrongfully denying insurance. The trial court actually found in favor of the landlord on the grounds that there was a duty to defend in light of the non-habitability claims, citing Buss versus Superior Court, which I mentioned earlier.
Which is a Supreme Court case. So that is the law of the land. At least it was as of the time the trial court made its ruling.
Exactly. So the trial court followed Buss and did not follow the plain or strict language of the exclusion, but the Court of Appeal reversed, finding that Northfield had permissibly contracted out of the Buss rule by including clear language that the exclusion applied to any claims alleged in a suit that, quote unquote, also included habitability claims. Now, there were no other published California cases dealing with this kind of habitability exclusion, but the court did cite a case involving a similar type of intellectual property exclusion, which had similar catch-all language, and used that as part of the basis for its ruling. I think it's noteworthy that the intellectual property exclusion in that case, the SBCC case, nonetheless still contained certain exceptions to the exclusion for certain kinds of bodily injury and property damage and advertising injury claims. So it was not quite as all-encompassing as the habitability exclusion in 24th and Hoffman. But the court in 24th and Hoffman chose not to distinguish the case or find that that language was dicta, or that holding was dicta. It's also interesting to note that the 24th and Hoffman court, chose not to take an escape hatch in following a couple federal district court decisions, one in particular called Sarman Construction versus Ironshore Specialty Insurance, which found that a similarly worded mold exclusion was unenforceable under Buss because the obligation under Buss, it noted, was not rooted in the contractual language itself, but rather was based on public policy. But the 24th and Hoffman case found that case was not controlling and not persuasive and didn't follow it. Instead, it found that its ruling didn't run afoul of Buss because Buss was essentially irrelevant based on the language of the policy. And the court recognized, as you see the quote there, the oddity of an insurance contract that covers certain claims against the insured if those claims are filed in a lawsuit on their own, but not if such claims are brought in a suit that also alleges habitability claims. But they said, even though that is kind of odd, that's what the contractual language requires, and it was clear and unambiguous. And the policyholder filed a petition for review to the California Supreme Court, but it was rejected. So 24th and Hoffman is the law of the land.
Yeah, it's that you're right. That could be. Well, what do you think is going to happen there? Do you expect what effect do you expect this case will have?
Well, I think it's entirely possible that carriers who don't want to have to defend certain kinds of claims, such as intellectual property claims or habitability claims, or any other class of claims, can now modify their exclusions to have this and also language in those exclusions, and avoid the situation where you have one potentially insignificant covered claim, which is really tangential to the meat of the case, and get out of having to defend that entire case.
And the case kind of boils down to the word also, I think, right? Because the standard, the exclusions that you typically see are exclusions, discrete exclusions for individual types of claims, like mold, for example. But you don't see in most policies, and also any claim that alleges a covered claim and also an uncovered claim. That's
the key. And it's worth noting that for people who do any kind of work in the habitability defense area, or plaintiffs for that matter, that there are a number of different habitability exclusions out there. And most of them don't contain this, at least not yet, don't contain this and also language. They may contain a very ironclad habitability exclusion that clearly covers habitability claims, but it's not uncommon in the habitability cases for there to be alleged some other type of injury that's covered, such as a wrongful entry, for example, into property, or wrongful eviction of a tenant in conjunction with a habitability claim. And so under those other habitability exclusions, there still typically is a duty to defend. But for this one, where you've got that and also language, that's going to be a problem. And we will see as the policies get reissued and as the cases start getting litigated, what fruit this bears.
Well, as you said, both plaintiffs and defendants in these habitability cases should take notice, because the bus case has been a source not only of defense, but also of indemnity for mixed claims, because the bus case allows the insurance company to recover money spent on uncovered claims to the extent they can prove that the services were exclusively for the uncovered claim, which is a very high bar, and has, for the most part, keeps insurance companies from filing a bus action, a post-settlement or post-resolution claim. So as a practical matter, in most cases, having the insurance company on the hook, so to speak, has been very valuable for commercial landlords.
Most definitely. And so the expectations of what's going to be covered potentially and when you're going to get a defense may be changing.
Yeah.
But we shall see.
Yeah.
Okay. So now we'll move on back to Mike for a couple of cases that have to do with the perennial issue of cutting down your neighbor's trees.
Yes, right, exactly. So the first case is the Thompson case. And I have headlined these as the incredible shrinking authority of Ledesma and Meyer. So if you take a long view of the issue of intentional acts in CGL policies, for years, the law was that that intention was viewed by the result. In Gray versus Zurich, which was a case from 1966, a fellow was sued for injuries that he caused allegedly to another person in self-defense. And the idea was, well, he punched him, but he was defending himself. He didn't mean to hurt him. He was just trying to defend himself. And that all changed in 2009 with a case called Delgado versus Interinsurance Exchange. We'll get to that later. So there are many cases now that relate to going on another person's land that you think is yours and doing some damage to the land and getting sued. So the first case is this, and the latest of these cases is this Thompson versus Crestberg, right? So the Thompsons owned property. It was subject to an easement by another entity. They sent some workers over to the next property and damaged the servient tenement, and it got sued for it. So they tendered, they had two policies, they had more than two policies actually, but they tendered on their CGL policy to Burlington Insurance Company. Burlington denied it because there was no occurrence, because the the work was intended to be done. They intended to cut a tree, they intended to move around some dirt and so forth. So the rule is that damage resulting from a deliberate act is not an occurrence absent some additional, unexpected, independent, and unforeseen happening that produces the damage. So if the insured intended all the acts that resulted in the injury, then it's not an accident just because the insured didn't intend to injure. The focus is on whether there was intent to commit the acts that are alleged. So the Thompsons sued Burlington, and they lost in the Court of Appeal, the Ninth Circuit Court of Appeal. Then they turned to Crestbrook, which had issued a homeowner's policy, and Crestbrook also denied tender. And Thompson sued them. And the Crestbrook moved for summary judgment, and their summary judgment was granted by the trial court using the same analysis, which is this intentional act versus occurrence analysis that the federal court had used in the Burlington case. So when the Thompsons appealed, the Court of Appeal, instead of adopting the trial court's analysis, ruled affirmed on the basis of issue preclusion, res judicata in essence. So here's in 2018, the California Supreme Court issued its ruling in Liberty Surplus Insurance Corp versus Ledesma and Meyer Construction Company. And they held that there could be occurrence-based coverage for the insured's negligent hiring, training, or supervising of an employee whose intentional acts thereafter caused damage. The Thompsons case against Burlington was pending when the Ledesma and Meyer case was handed down, but it was the opinion was published while the Thompsons were appealing before the Ninth Circuit. And the Ninth Circuit rejected that because the claim did not concern accidental conduct. And so when they sued Crestbrook, they argued that under the Ledesma and Meyer case, some of the harm could be attributed to negligent hiring or supervision of the contractors that caused the damage. Now, by that time, there were findings that the Thompsons had committed certain intentional acts, and that's what the trial court focused on in denying the summary judgment motion. The Court of Appeal said no. The decision of the Ninth Circuit in the Burlington appeal created issue preclusion because can we go to the next slide? And they went through the 5 factors, right? Identical issue, actually litigated, necessarily decided, resulting in a final ruling on the merits against a party or a privy. So the trial court distinguished Ledesma and Meyer in granting summary judgment to Crestbrook, but the Court of Appeal didn't rest its decision on that distinction. And Crestbrook was the one who had argued issue preclusion, and that was what the Court of Appeal accepted. So in the Thompson case, the Court of Appeal sort of dodged Ledesma and Meyer. There is in the opinion language that distinguishes it, but in this next case, which is Gukasian versus Aegis Security Insurance Company, the Court of Appeal took Ledesma and Meyer head on. This is a little more sort of straightforward neighbor to neighbor case, the kind of case that you see a lot of. Gukasian thought that the land that she had her crew go to trim trees and so forth belonged to her, but it actually belonged to the neighbor. And so her neighbor sued for trespass and negligence. She tendered to Aegis. They denied on the occurrence basis, and Gukasian sued. The carrier's summary judgment motion was granted, again on this no occurrence basis. So Gukasian specifically instructed her contractor to level certain land and cut trees, and that's exactly what they did. Gukasian's mistaken belief about the boundaries of her property is irrelevant to determining whether the conduct itself was intentional. So the Gukasian court distinguished Ledesma and Meyer saying that the employee's molestation of a third party, and that was what was involved in Ledesma and Meyer. The employee was sued for molestation. That might be an unexpected consequence of negligent hiring, but Gukasian's intentional conduct was the immediate cause of the injury without an additional independent act causing damage. So can we go to the next slide? Both of these cases narrowly construed Ledesma and Meyer. So the strict definition of occurrence still applies. There's no liability coverage for intentional acts causing damage unless the damage results from additional, unexpected, independent, and unforeseen happening. So, for example, in Ledesma and Meyer, obviously, the employee wasn't hired to molest somebody. That was unexpected, independent, and unforeseen. And I suppose in the Gukasian case, if the crew had gone on to I don't know, light a fire or smoke a cigarette that then was thrown on the ground and started a fire, maybe that would be an additional unexpected or independent or unforeseen happening. But for practical purposes, Ledesma and Meyer and this potential coverage under the standard CGL policy for negligent hiring, training, or supervision is going to be pretty narrowly construed.
Mike, we have a question which I think is addressed to these tree cutting cases, which is, how is the tree cutting different than a faulty workmanship case?
Well, the tree cutting, there was no evidence well, actually in Thompson, there was an argument that that the scope of the permitted work, or the scope of the work that the Thompsons had directed these folks to do was exceeded by the contractors. But there's no, these aren't cases about the quality of the work or defects in the work. They're cases where the hirelings actually did what they were hired to do, competently, completely. They're not about the quality of the work. They're not about defects in the work. They're about people doing what Gukasian or the Thompsons hired them to do. So that's the issue, I think.
Okay. So all of this, including, ties in with a little bit with insurance code 533, which says that you can't indemnify under California law for willful acts. We had a question earlier about the TCPA claim just barred under section 533. I think the answer, I'll take a stab at that before I move on to this Conagra case. I think the answer to that is the personal injury. A lot of the personal injury offenses that are covered under a CGL policy, such as invasion of privacy or malicious prosecution, notably, those are things that are often intentional, defamation, and oftentimes there's not actually going to be coverage for indemnity, but there is going to be a defense provided, which is, a lot of the time is 90% of the battle. But I think that's the answer to the TCPA question. This case, I think, is mostly of interest because it involves questions of insurance to successors under successor liability. This is Lloyd's versus Conagra Grocery Products. Conagra was seeking indemnity from its liability insurers from going back many, many years because they had been sued for nuisance, public nuisance created by the sale going back over 100 years of lead paint. And the predecessor to Conagra, not the immediate predecessor, but going way back, who was promoting the paint, was W.P. Fuller. And there, in the underlying public nuisance case, Conagra was held liable based on Fuller's intentional promotion of lead paint for interior residential use. And lead paint manufacturers in those years were promoting their product despite the fact that the deleterious effects of lead on human beings has been known for close to 100 years. That's not something that only came to light, recently. And so they were held liable for it, and therefore Conagra, which purchased that corporation many years later, was also held liable for it. Conagra wanted to have its insurance carriers who were on the risk during some of the time period at issue pay for that, saying, hey, it wasn't us who intentionally promoted the lead paint. But they lost, and the Court of Appeal upheld summary judgment in favor of the insurers under Insurance Code Section 533. This is notwithstanding the fact that, as I mentioned, Conagra did not even directly purchase Fuller. There had been at least two or three other entities intervening between the time that Fuller was doing this willful promotion of a hazardous product and the time that Conagra bought the company. Nonetheless, the court found that Section 533 did apply and rejected the argument that because they were just a successor, that application of Section 533 was not appropriate. The court held that the successor in a merger situation is on notice that it's purchasing the predecessor's liabilities. They also rejected the argument that the loss was too attenuated to give rise to coverage, finding that, well, hey, in the underlying case, Conagra was held liable for what Fuller did, so the same causation analysis essentially would apply to the coverage obligation and whether the willful act, gave rise to the nuisance claim that they were seeking coverage for. And finally, they rejected the argument that it had not been shown that Fuller's high-level corporate managers acted with the requisite knowledge. Conagra was sort of seeking to try and import a kind of punitive damages standard for deciding when the corporation should be found to have acted willfully or not. And the Court of Appeal said, no, that level of proof is not necessary. It's enough that in the underlying litigation, the corporate entity had actual knowledge of the harms.
I wonder, Steve, if there is a product, an insurance product that would cover an acquirer under circumstances like this. I mean, maybe there's some kind of merger and acquisition insurance that would cover, unforeseen or, unlikely losses, something like that. I don't know. I've never.
I don't know that either. I do know that where underlying claims are based on negligence and not willful acts, it is possible that insurance companies can be on the hook in a successor situation, but I'm not sure that you can buy coverage that would cover something that your original predecessor in interest did willfully. I sort of doubt it. Okay, well, let's move on now to something diverge from case law, which we don't normally do, but there's some new statutes that are in effect now as of 2023 that are so significant that we wanted to spend some time on them today.
We every year, it seems, there will be a case where a plaintiff's lawyer will send a policy limits demand to an insurance company with some very short fuse on it. You have a week to answer, you have 10 days to answer, and then if you don't, then they will argue that they have what they call blown the lid off the policy. They can create ground. I shouldn't say create. Sometimes it serves as an argument that there are grounds for a bad faith claim, either by typically, obviously, that since Maradi Shalal, that would have to be assigned by the insured defendant to the plaintiff, often in a settlement, but sometimes after a judgment. We see one of those cases almost every year. And I guess the insurance companies went to the legislature and worked with legislators to get a statutory fix for that. And this is the new Code of Civil Procedure, Section 999 et sec. So it's 999 through 999.5. 999 states a public policy to prompt settlements of civil actions as beneficial to all parties, right? Extra contractual damages, of course, that's the bad faith damages. And these are more or less definitions, right? The key is this second one, a time-limited demand, right? An offer prior to the filing of the complaint or demand for arbitration to settle any cause of action or a claim for personal injury, property damage, bodily injury, or wrongful death by a claimant to settle the claim against a tortfeasor within the limit of liability insurance, which by its terms must be accepted within a specified period of time. Okay, so that's what now 999 through 999.5 apply to, are these time-limited demands. A 999.1 says 999.1, which is the next slide, says what a time-limited demand must contain. And how it must be served, right? So has to be in writing, has to be labeled as a time-limited demand, or reference this section, meaning 999.1, and contain material terms, including that the time period can't be less than 30 days. This emphasis is added by me. And if it's by email or fax or certified mail, it's 33 days. So it's only 30 days, I guess, by personal service. But you have to give the insurance company essentially a month to respond. A clear and unequivocal offer to settle all claims within policy limits, including the satisfaction of all liens. That's obviously liens for medical care and other costs of the claimant. An offer for a complete release from the claimant for the liability insureds from all present and future liability for the occurrence. So that's a full release. And then some others on the next page, but the date and location of the loss, claim number if known, description of all known injuries, reasonable proof, which may include, if applicable, medical records or bills sufficient to support the claim. So that is really for purposes of persuading the insurance company that you're going to that the claim exceeds policy limits. The next slide is 999.2. So the claim should be sent to an email address. You see that 999.2b talks about the Department of Insurance posting on its website the email address or physical address designated by an insurer for receipt of time-limited demands. The next one is what I think is the key. So you give the insurance, you send one of these correspondences to the insurance company, you say you've got 30 days to respond. But if the insurance company, upon receipt of a time-limited demand, tries to seek clarification or additional information or request an extension due to the need for further information or investigation, and they make that request within the 30 days, then that's not deemed a counteroffer or rejection. Now, if the insurer does not accept, this is now 999.3c, a time-limited demand, the insurer shall notify the claimant in writing of its decision and the basis for its decision prior to the expiration of the time-limited demand, including any agreed extension, and that shall be relevant in any lawsuit alleging extra contractual damages against the tortfeasor's liability insurer. But it seems to me that 999.3b threatens to give the insurer kind of an open deadline. If they ask for more time for additional information, clarify, request an extension, then the 30 days or the 33 days does not apply. And the next slide is 999.4. It says that in any lawsuit filed by a claimant or by a claimant as an assignee of the tortfeasor or by the tortfeasor for the benefit of the claimant, the assignee and for the benefit of, that's typically what happens if you obviously if the plaintiff in the underlying case gets a judgment or settles against the insured party, they'll usually take an assignment of the bad faith claim. A time-limited demand that does not substantially comply with the terms of this chapter shall not be considered to be a reasonable offer to settle the claims for purposes of any lawsuit alleging extra contractual damages. That means that it's not evidence to support a bad faith claim, which is what the plaintiff will accept an assignment of. but what's interesting is C 999.4C says, in the event a court determines that this chapter conflicts with the Civil Discovery Act, the Civil Discovery Act shall prevail. That's kind of mysterious, but I suspect what it means is that the bad faith claimant can at least raise the request, the time limited demand, and the way that the insurance company responded to it, even if there's not compliance with these statutes for purposes of supporting a claim. I imagine that's probably a concession that the bad faith plaintiffs bar got out of the legislature. So 999.5 is the last of these statutes, and it applies to time-limited demands transmitted on or after January 1, 2023. So it's not retroactive. It repeats that it only applies to these causes of action for standard liability claims, nothing shall alter existing law, including law relating to claims, damages, and defenses that may be asserted in litigation seeking extra contractual damages. So obviously there are plenty of bad faith cases that aren't these short fuse time limited demand cases, and this statute doesn't apply in any way to those kinds of cases. It is a legislative attempt to eliminate those short fuse cases that, as I say, have kind of bedeviled the courts for years.
So I guess one point that bears repeating, Mike, is this whole construct only applies to pre-lawsuit demands.
Right.
So in theory, once the lawsuit is filed, the plaintiff's lawyer can go back to the strategy of sending a fax to the carrier on a Friday afternoon demanding, acceptance by Monday morning, which I think was one of the case scenarios that we had a few years ago, as long as the lawsuit has been filed.
That's a good point. That's a good point. And I think there is that loophole, so to speak, in it. And that may be also, I mean, if you read the sort of popular insurance bar press about this, I've seen it referred to as the product of negotiation between the plaintiffs and the defense bars in bad faith cases. And that may be another, like the mention of the Discovery Act, that may be another item that the plaintiffs bar negotiated to limit its application to just these pre-lawsuit communications, and still allow, as Steve says, for post-filing gotchas, we might say.
Right. And I'm not condoning that type of offer. I'm just saying that that's what some plaintiffs' lawyers do. I guess the other thing I think it's worth maybe emphasizing before we move on is that this chapter applies only to automobile, motor vehicle, homeowner, or commercial premises liability insurance policies for property damage, personal or bodily injury, and wrongful death claims. So a few notable things that are not mentioned here: employer's liability coverage.
Fire insurance.
What's that?
Fire insurance.
Well, that would be
homeowner, I guess. Homeowner. First
party claim probably, but professional liability, so like errors and omissions claims, not included within these strictures, at least not yet.
Right.
At least not yet.
Right.
Okay. So let's move on to some first party cases. And once again this year, we have a whole section devoted to COVID-19 policies. COVID-19, everybody's favorite topic. And as we've talked about over the last couple of years, the potential for coverage, first party business interruption coverage for policyholders who suffered as a result of COVID-19 has pretty much amounted to a hill of beans, has not panned out for policyholders. And so we had, last year we had sort of the most important or the first, I guess, case in this area from the California Court of Appeal called Inns by the Sea, which found that a lost business income claim was not going to be honored because it did not result from, quote, direct physical loss of or damage to property, which is the key language for a first party claim. What we had in 2022 was several other California Court of Appeal cases that picked up on that and followed it, and then followed by a couple of outlier cases, which we'll talk about in a minute. So, among the cases that affirmed or followed ends of court was the Musso and Frank versus Mitsui Sumitomo case. Like, all of these first party policies, it covered the loss of business income caused by direct physical loss of or damage to property at the premises. And the court construed that to require some physicality to the loss. There actually has to be some kind of physical alteration or destruction in order for the policy to apply. And as they held at this point, they said there's no real dispute that under California law, a business interruption policy that covers physical loss and damage does not provide coverage for losses incurred by reason of COVID-19. You then had the United Talent Agency case in short order after that, another division of the Second Appellate District. The last case was Division 1. This is Division 4. And United Talent Agency tried to make some, get around the case law in some other ways, saying that there was the alleged presence of COVID-19 and that should be enough to trigger coverage. They also tried to trigger coverage under the civil authority provision, which says that if a civil authority shuts down your business because of a loss that occurs at some location other than your property, then you're entitled to the lost business income from that as well. But the Court of Appeal again followed ins and said that the mere potential presence of the virus in the covered property does not constitute direct physical loss. And there was also no coverage under the civil authority provision because that also requires that there be a physical loss or damage somewhere away from the covered premises, and that the purpose of the closure orders was to prevent the spread of COVID-19, not as a result of direct physical loss to damage. So for example, if there was a fire in the building next door to you and the building was in danger of collapsing or something, there was damage away from your covered premises, but you weren't able to get into your building because the city, had red tagged your building or temporarily prohibited access. It was not that kind of situation because there was no physical damage to anything. And then you had the First Appellate District get into the act in the Apple Annie case, which, again, rejected an argument that was often made as, well, hey, the policy says two things. It says direct physical loss of or damage. And those should be considered to, loss and damage should be considered to be two different things. But the courts have pretty much unanimously rejected that argument. Then comes one of the outlier cases that I mentioned called Marina Pacific. And by Division 7 in the Second Appellate District. And I thought that case started with an interesting quote. They said, for more than 2 years, our understanding of COVID-19 has evolved. Today, we think we know how it spreads, how to prevent against it, and how best to treat those who have it. Perhaps we do. But even so, when a pleading alleges facts sufficient to constitute a cause of action, what we think we know, belief not yet appropriately subject to judicial notice, has never been a proper basis for sustaining a demur. And, when we think back to the beginning of the COVID-19 pandemic, there were an awful lot of theories and perhaps even assumptions, which turned out, not to be the case as we learned more. And in the complaint in the Marina Pacific case, the plaintiff, citing some journal articles, actually did allege that there's scientific basis to argue that the virus actually bonds and or adheres to objects through physiochemical reactions. causing physical alteration to the property. The trial court, basically looked at the case law that said, no, COVID-19 doesn't cause physical loss or damage, and threw the case out. But the Court of Appeal in this case said, well, they have alleged physical damage to property, and there's not, any sufficient agreed upon treatise on, whether that's true or not, that we could take judicial notice of to obviate that allegation. And therefore, assuming the truth of the allegations, even if they're improbable, we have to essentially take them as true and let this case proceed. Of course, whether they can prevail at summary judgment is an entirely different matter. However, the viability of Marina Pacific may be short-lived, because just very recently, out of the Ninth Circuit, there's a case called Another Planet Entertainment, where you had a promoter making a similar argument or similar allegation. They argued that the droplets of COVID-19 physically alter the air and airspace and the surface of both the real and personal property to which they attach. The district court, like the trial court in the Marina Pacific case, dismissed the complaint with prejudice, but the Ninth Circuit has certified the question to the California Supreme Court. And you see the question there. It says, can the actual or potential presence of the COVID-19 virus constitute direct physical loss or damage? To my mind, those are two different questions. Actual or potential are quite, different questions. But in any event, that's the question that the California Supreme Court just granted review on last week. So maybe next year, or perhaps more likely the year after that, we'll report to you on what the result was from the California Supreme Court. There's one other COVID-19 issue that is perhaps a little more niche. It did not involve a business interruption claim, but rather Amy's Kitchen, which manufactures those delicious vegetarian products that you see there up on the screen, purchased a communicable disease coverage extension. And what that extension said is that there was coverage for direct physical loss or damage to property insured caused by or resulting from a covered communicable disease event, including costs to mitigate, contain, remediate, treat, et cetera, the communicable disease. And you see what the definition of communicable disease event is there. The public health authority has ordered the location to be decontaminated, evacuated, disinfected. There was also a loss avoidance provision, which covered necessary expense that you incur to avoid or mitigate potential covered loss. So Amy's alleged that it had incurred those kinds of costs to mitigate against the coronavirus at its manufacturing locations, as you might imagine. The trial court dismissed the case, but the Court of Appeal rejected that dismissal in light of the specific inclusion of mitigation costs in the extension. And so, where otherwise there might have not been any direct physical loss or damage, this court found, well, hey, that would render the communicable disease extension and the loss mitigation provision illusory. And so we're not going to, regardless of whether COVID-19 actually causes physical, transformation of property, we're not going to exclude coverage for that. There are also, there's another case involving a similar coverage called John's Grill, which was decided recently, which is a little different because it had that coverage, but it also had a virus exclusion. And similarly, French Laundry, same thing. They had that coverage, and yet they had the virus exclusion. And, there's a question as to whether the virus exclusion renders the coverage extension illusory. Both of those are pending for consideration by the California Supreme Court. And I don't know whether the court will grant review of either or both of those. But again, that's one for the future. Let's see, we only have about 5 minutes left. we have a few first-party policies to talk about that are kind of niche, but I think the one that will be of most interest as we wind down here would be Ernst & Haas, Mike, if you wouldn't mind spending a few
Sure.
minutes on that.
So Ernst & Haas is a phishing loss of funds from fraudulent email. In this case, there was a fraudster sent an email impersonating the boss and asking that $200,000 be paid, and the employee made that $200,000 transfer, and of course he wasn't the boss, and the $200,000 didn't go to a proper creditor. So they were insured by Hiscox, and Hiscox denied rejected their tender and denied coverage. The district court, Ernst & Haas sued in federal court, and the district court found that the loss was not the direct result of the fraudulent emails, and it dismissed Ernst & Haas's complaint. The Ninth Circuit reversed. The trial court's analysis was based on a case called Pestmaster, which is a Ninth Circuit case from 2016. It's in the federal appendix. You see the citation. That was a case. Some of you people might recall it. It was a case involving a payroll service that had authority to make payments. I think it was payments of the taxes with withholding from its clients' accounts, and it was somebody, I believe, an employee of the payroll service that had made those fraudulent transfers, and but also by online transfers. But the court found that there was no coverage for those because the transfer was made by someone who was authorized to make those transfers, but it was basically an embezzlement case. The district court applied Pestmaster in dismissing Ernst & Haas's claim, but the Ninth Circuit distinguished Pestmaster because the authorization, the person impersonating the boss, was fraudulent. There was no one who was ever actually properly authorized to pay anyone. Obviously the employee was following the directions of somebody that the employee thought had the authority to do that, but there was nobody who actually was authorized to do that. So the Ninth Circuit found that complying with the fraudulent email caused an immediate loss, so the computer fraud coverage applied, and that a fraudulent instruction resulting in directions to the bank to transfer the funds was also covered under the funds transfer fraud. So, obviously we're all concerned about phishing and computer fraud, and the Pestmaster case was viewed, and it was a case that denied insurance coverage for a loss like that due to phishing and computer fraud. So it's good to know that at least in the federal courts, there may be coverage under certain circumstances for at least these impersonation claims, and that's what most of the phishing claims are, obviously. So your policy may, as an employer, as a business, may provide coverage if you get hit in a phishing scheme. So,
and if you've purchased either your sort of first party business policy or a separate cyber liability policy, this particular kind of coverage, computer fraud or funds transfer fraud, right?
Right.
Okay. Well, so last point, you have the full PowerPoint in your materials if you are interested to take a look at some of these other cases that came down. I did just want to spend a moment on the two cases that are currently pending before the California Supreme Court. They'll probably be of somewhat limited application to most of our viewers today, but one of them involves another perennial question of in these big pollution cases or asbestos cases, how do you decide the priority of coverage as between primary carriers, as between primary and excess carriers? Is it vertical exhaustion? Is it horizontal exhaustion? We have this case, Truck Insurance versus Kaiser, which is a review, interestingly, of an unpublished case, but I think review is granted because it diverged from another published case decided in 2020 called Santa Fe Braun, which reached the opposite conclusion as to whether there should be vertical exhaustion or horizontal exhaustion. And then lastly, a case which somewhat inexplicably to me anyway has been pending for an awfully long time. It's been fully briefed, I think, for over a year, but we don't have oral argument set on a very niche question of trucking insurance and how to properly terminate coverage under the California equivalent of the motor, or I guess of the Motor Carriers of Property Permit Act, which is a California statute. There's a federal equivalent, and whether the coverage can continue even though you forget to notify the DMV that the policy has been canceled. That is also pending, has been fully briefed for a long time. So with that, I want to thank everybody. I hope that we see you back in a year when Mike and I will hopefully do our annual presentation again. I think the only year that we've missed for the last several was 2020 for obvious reasons, right around this time. But otherwise, it's a pleasure. And thanks, Mike, for being my partner in this.
Well, thank you, Steve, and thank everybody who's tuned in. We hope you found it worthwhile and enjoyable. We'll see you next year.